Each party will have up to 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know because I'll be keeping track of it and I'll try to alert you when you move into your rebuttal time. The arguments are being recorded, so please come up to the podium, stay behind the podium, introduce yourself, keep your voices up, and you should not use the names of children or minors or victims. If that is relevant for your argument, you can refer to those people by initials or general terms like the child. We have read your briefs and we're ready to proceed when you are, and I would just ask appellant, do you want to reserve time?
I'll reserve the full 5 minutes for rebuttal, Your Honor.
Okay.
I'd like to take the full 15 minutes for rebuttal, but I looked at the local rules, it's not permitted.
No, 5 it will be.
Okay.
You may begin when you are ready.
May it please the court, and good morning, Your Honors. I know you've read the briefs, so I'm not going to go through them again. I would just like to say that at this stage in the oral arguments, I stand by what is set forth in the brief and the reply brief as well, which responded to the state's arguments. I really don't have anything additional to add to my briefs. I didn't want to waste the court's time just reiterating, because I know it can read, obviously. So if there's any questions, I'm more than happy to answer them, but if not, then I'll just reserve my time to respond to the state and give the state the floor.
Very well.
Thank you.
You will have your full 5 minutes.
Thank you.
May it please the court, my name is Jeff Holland, Supreme Court registration number 0040089, representing the state of Ohio, the appellee in this case. Your Honor, there are four issues that are raised by the appellant on this appeal. First one is probably the strongest one, which is the waiver of the jury and withdrawal of the jury demand. Your Honors, I think that revised code section 2945.05 is fairly clear. There's also a significant case law that indicates that where a person has a right to a jury, and that jury is not waived in open court with a signature of the defendant and so forth, that kind of a matter is must be remanded. So if that were the end of the case, we'd be retrying this case. The thing that we found that may make this a little bit different is that, of course, in a felony case you have an automatic right to a jury trial. In a misdemeanor you do not. In a misdemeanor you only get a jury trial if you file a written notice for a jury demand. Written notice for jury demand was filed in this case early on. And then on the day before the jury trial, appellant's counsel filed a pleading, and the wording of the pleading is important. So the wording of the pleading says, and now comes the defendant, K. Lackey, by and through counsel, and hereby gives notice to the court in the state that she is hereby waiving a trial by jury, period. Next sentence is, she is also withdrawing her demand for a jury trial. Your Honor, there is little case law on this issue, but in general, a withdrawal of a pleading is to withdraw it entirely from the proceedings, as though it did not exist. And so, if there are two things that are said by defendant in this case. One of them is, I'm waiving the jury. One of them is, I'm withdrawing the jury demand to begin with. Now, there would be no requirement for a waiver of a jury if in a misdemeanor case, the defendant never made a written demand for a jury. You wouldn't have to have a written waiver. But in this case, there was a written waiver that was filed initially. If it is withdrawn and is therefore no longer a part of the record and is no longer part of the pleadings because it is withdrawn, and the court granted that motion, then indeed there would be no need for the court to go through that procedure.
This is a very interesting argument, and when I was thinking about it, once they made the demand for a jury, like you said, there's a jury trial right in a felony prosecution.
Yes.
But once they demand a jury trial or make a demand for a jury trial, that mean there becomes a right given to them in a petty case, in a misdemeanor case?
Yes, I think so.
Okay.
Yeah, I do think so.
How are you able to withdraw that right just by withdrawing the motion?
Well, because the withdrawal of it only vests or only occurs when the motion is made. If the motion is withdrawn, in other words, if I withdraw a question at trial or I withdraw a motion, the court is not to consider it as though it was not filed.
Except that in those situations, you're not necessarily talking about an inherent right, and a right that's given to you to have a jury trial in this instance. In other words, this is a very interesting, like I said, argument. I've
It's
never
what we
had.
have.
But I'm just trying to figure out how that takes away, you know, a right that is given to you under the law.
Yes, Your Honor, in my view,
Okay,
the right is not absolute for a misdemeanor.
okay,
The right requires a written notice in advance of trial in accordance with the criminal rules and in accordance with statute. And where that written demand is made and then voluntarily withdrawn so that it no longer is essentially part of the proceedings, then it was not made, it is a nullity. And I think that's a meritorious argument to be made, Your Honor.
so you're differentiating here and saying that even with a demand for a jury trial, it's not an absolute right?
That is correct.
Okay.
And, if you have a misdemeanor and you never make a demand for a jury, you're not going to get a jury. And you're not entitled to have a new trial because you failed to waive a jury trial in writing. You don't have to go through that sort of thing. So that addresses that. Is certainly the strongest issue that appellant makes.
So counsel, if this court were to decide that a new trial is necessary
Yes.
under the law, then do you have anything to say about the rest of the assignments of error?
Yes, I do. So the other assignments of error, number 2 is the stipulated facts. And Your Honor, this is, I believe, an abuse of discretion issue. And in this case, we had 2 attorneys that represented the defendant in this case. The initial attorney was dismissed and filed a withdrawal, but prior to doing that, entered into stipulations with the court of certain stipulations of fact. Now, the question is whether or not the court abused its discretion by not allowing the withdrawal of the facts, the stipulated facts within just a few days prior to trial. That's the question. And in this case, we've got a couple of things going on. I guess number 1, the issue is that the defendant was charged with 3 counts of animal neglect, essentially. 2 of them were misdemeanors of the 2nd degree. 1 of them was a misdemeanor of the 1st degree. The misdemeanor of the 2nd degree and the misdemeanor of the 1st degree are identical, which mean that which essentially boils down to negligently failing to provide any care to an animal such that it could cause unnecessary or unjustifiable pain or suffering. And in this case, we had 9 dogs that were kept in conditions of extreme filth. One of them had a claw that curled all the way back and pierced the animal's paw. One of them had to be euthanized because it was confined in a cage, it was too small. But there are those kind of facts out there. The only difference is that whether or not a person is either the operator or owner of or employee of a dog kennel. A dog kennel includes an animal rescue for dogs. And one of the things that we pointed out is that part of the testimony, and I don't think this solves this resolves all of the issues, but part of the testimony certainly indicates that she was keeping dogs for a nonprofit animal rescue for dogs. That's specifically defined in statute, and that evidence is not absolute evidence that she was an employee of that organization, but it certainly is circumstantial evidence. And she makes this admission after being asked those questions by her own counsel at trial. So, so we believe that that is not a legitimate issue. The judge took those stipulations months before the trial. Within a few days before trial, there was a request for those to be overturned. And the question is whether or not the judge acted with abuse of discretion. And then the other element to this is assignment of error number 4, which is ineffective assistance of counsel, which is on the same issue. And the question is whether or not defendant's appellant's original counsel was ineffective when he entered into these stipulations to begin with, because we now have a new attorney who's second guessing what happened with the old attorney. And I would suggest to you that, of course, we know that ineffective assistance of counsel, there's a broad range of any kind of objective ways that you might structure or decide on strategy for a defense of a case. And in this case, it probably was a wise thing to do for counsel to stipulate to the individual being involved with an animal rescue or being involved with a kennel facility, because if you had to get into the actual evidence, it would necessarily mean talking about the conduct of that business and would raise the likelihood of bringing up things like the knowledge of the appellant about the appropriate care of dogs and so forth. And by taking that and setting it aside, we no longer had to get into testimony about, well, you ran this kennel, you operated this animal rescue, you did all these different things, you should have known better, you had all of this various knowledge. That's a legitimate trial strategy. So we think that is without merit as well. And finally, the third assignment of error is the defective complaint. I think this is the weakest of the appellant's arguments. Essentially, the complaint itself is clearly signed by the clerk, and it's sworn by the clerk, and it even gives the year in the jurat. It says 2023 is when it was signed, but they didn't write down the day and the month, and so for that reason, appellant asserts that the entire complaint is incorrect. And when this was brought originally to the trial court's attention, trial court said, no problem, we'll just have the individual re-swear this and re-sign it, and we'll re-serve it, and then appellant's counsel accepted service in a certain way, which then occurred. So I think that is probably not a legitimate, meritorious argument, and that's what I have here.
Thank you very much.
I thank you for your kind attention.
I apologize, Your Honors. I forgot to give my name. My name is Michelle Huth, and I'm the appellant's attorney, obviously. 009135 is my phone number. Just 3 quick issues. So the stipulated facts stated that at all relevant times the defendant was the owner, manager, employee of a dog kennel. What the state has done is it's done, these are not the droids you're looking for, and it's trying to switch it around and say, well, now we're making the argument in our brief, making a totally new argument that now she's a foster. Foster equals an employee. Employee equals, employee of what? Employee of the rescue she's fostering for, or employee of a dog kennel? They're kind of mixing up, claiming that a foster is an employee under the statute. So, I mean, I think the statute's very clear on what it says, and that it has to be a dog kennel or rescue or whatever. And the law does not support the state's argument that a foster somehow equals an employee of a rescue. God forbid, I foster all the time, that would be a horrible thing. And then you just have to start paying taxes and things like that too. Do you get to deduct your expenses? I mean, that's a whole tax nightmare.
Counsel, let me ask you, whenever the attorney for the appellant here filed the motion to withdraw or asked to withdraw the stipulations, what was the rationale given?
I was the second trial attorney. I'm the one that asked. The rationale was that my client did not run a dog kennel or a boarding facility. She had a business. It was a training business, but it ended the October before. So that's why I go back to that. There's no way that this the initial trial counsel, with a straight face, could agree to a stipulated fact that's not a fact, which is one of the elements or standards for ineffective assistance of counsel. There's no basis in fact at all for this. Obviously, the state wants it to be like they're arguing because it was easy for the state to get these stipulated facts. I mean, I don't want to say it was easy, but once they got the stipulated facts, totally eliminated the main essential element of the misdemeanor 1 charge, which was the most highest offense. She ended up getting jailed for it and got her out after 3 days.
Counsel, the reason I ask that is because I'm just wondering what we're gonna find in the record in regard to, the veracity of the stipulations as well as whether or not, the appellant actually did not want that stipulation, which is what she's alleging now.
The only thing that's in the record is my motion to withdraw, which states some facts that she didn't run a training facility. But when we try to start questioning stuff during trial, as you can see from the transcript, the court was not allowing us to elaborate. If I had, I don't recall, but I think I got in that she testified she didn't run the training facility, but I don't know if the judge cut us off before she got to answer on that. So the judge was very adamant on that. I didn't
Counsel,
want to.
could you please go back to assignment of error number 1 and respond to?
Yes, I'm not a criminal defense attorney. I occasionally do criminal defense work with assistance with other attorneys. I just read the law and wrote out the law in my assignment of error as I saw it. That the first counsel did a demand for jury trial. My client decided she didn't want one, so I did a withdrawal. I assumed that prior to the trial, the court would address us and ask my client directly if she agreed to not have a jury trial, but none of that happened. I don't really have anything substantive legally to argue with you guys, and I'm sorry, but because I'm not that familiar with, I know that a jury trial is not required on a misdemeanor, but I still believe if you do a demand for discovery, and you have a right to withdraw that the court is still obligated to follow certain constitutional procedures to make sure that the person has a knowing, willing, and voluntary withdrawal of the jury trial. I mean, what happens hypothetically if the attorney did it without the client, if the attorney just goes ahead and does it like he did in the stipulated facts? I mean, I still believe that regardless of whether the jury trial is mandatory or not for the offenses that she was charged with and prosecuted with, that she still had a right to knowing and voluntary withdrawal of that jury trial, not just my motion, but additional stuff, which I had assumed that the court would do, but it didn't. And I'd like to just say lastly, Your Honors, I have 32 seconds, is that the state is going into guessing why the initial defense counsel entered those stipulated facts. There's nothing in the record to be able to say why he entered those stipulated facts. There's nothing in the record to say whether he consulted with the client or not, other than to know that my motion specifically states that he did not consult with her, and she didn't even know about the stipulated facts until after the stipulated facts had already been entered into. So I believe that the state is being a little bit loose with some of the facts about what the thought process was on entering the stipulated facts. But I know that my client, the appellant, was not involved in the decision before, during, or after, and was not in the room when this happened. Thank you, Your Honor. Perfect timing. Thank you.
Thank you, counsel. Thank you both for your presentations. The court will take it under advisement and issue a decision in due course. The clerk of courts will send you a copy of that decision to you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website.
Thank you, Your Honor.
Again.
Thank you, Connie.